Yes, Mr. Duffy.
My Lords and my Lady, this morning the appellants relied quite substantively upon the explanatory notes to the Serious Crime Act in assistance of an interpretation of Section 160A and how it should be applied. But it is useful, we submit, to look a little bit further into the parliamentary intention underpinning the amendment which was ultimately introduced as Section 160A. And I've asked my Lords and my Lady to look at MS 57, which is in the Volume 1 of the two bundles before this court, to refer to some extracts from Hansard, which unfortunately weren't replicated in the second bundle, but which are set out quite extensively in the skeleton argument at MS 57. And the first portion of Hansard that we wish to draw the court's attention to is set out at paragraph 18 on MS 57, and it concerns statements by the then Secretary of State about the introduction of the amendment. And this was from the 5th of January 2015. And the Hansard reads, finally, in relation to Part 1, we are bringing forward the consideration of third-party claims from the enforcement stage to the confiscation hearing. Although there are undoubtedly third parties who have a legitimate interest in assets that may be used to satisfy a confiscation order, it is often the case that spouses and other third-party associates of the defendant will submit late claims with the deliberate intention of frustrating and delaying the confiscation process. The bill will enable the court to make a binding determination of third-party claims at the point at which the confiscation order is made, allowing the enforcement of the order to proceed more efficiently. And then, following on, paragraph 19, we cite from the committee debate of the Commons from the 13th of January 2015, when the Undersecretary of State said as follows: Clause 1 deals with the determination by a court of the extent of interest that a defendant holds in named property. The Serious and Organised Crime Strategy sets out proposals to strengthen the Proceeds of Crime Act 2002 by, among other things, ensuring that criminal assets cannot be hidden with spouses, associates, or other third parties. Confiscation orders are the principal method used by law enforcement agencies for the recovery of the proceeds of crime. It is open to the defendant to pay off the order out of what assets he or she has available. The confiscation order specifies an amount to be paid. It does not itemise particular assets that are to be forfeited. Third parties making claims on assets that are part of the available amount can delay satisfaction of confiscation orders. Such claims also reduce the amount of money available for recovery. Some of the claims may be perfectly legitimate. However, others will be spurious and designed simply to frustrate the confiscation process. To tackle such abuses and to help speed up the confiscation process, Clause 1 will confer on the court a power to make a determination as to the extent of the defendant's interest in particular property at the confiscation hearing. Currently, any claims on property are dealt with at the enforcement stage, which can complicate, lengthen and impede the confiscation process. In deciding whether to make a determination...
Well, I think we can read all of this for ourselves, Mr. Duffy. What's the particular point that you wish to make about it?
Well, the point about that, my Lord, is that when one then goes and looks at the explanatory notes, which are at M477 of the bundle, and particularly our interest is in paragraphs 19 and 21, which are two of the paragraphs which are cited on behalf of the appellant in support of their interpretation as to how and what circumstances and how often Section 160A should be used. So paragraph 19 of the explanatory notes, my Lord, my Lady, states, in general, it is most appropriate...
Well, we've had this read to us already.
The difficulty with that, my Lord, is that it's difficult to understand why, in light of the Hansard underpinning the amendment, why the explanatory notes say that it is most appropriate in general for third-party interests to be dealt with substantively at the enforcement stage. That particular observation in the explanatory notes, we respectfully say, is not supported by the Hansard and therefore does not appear, in fact, we respectfully say, to convey the intention of Parliament. We also suggest that the use of the...
I've just not found the place where it says most appropriate. Could you?
Sorry, it's at paragraph 19 of the explanatory notes, which is at page MS 477,
Yes, which
my lady, on the second bundle.
I've got that.
So we respectfully say that when the explanatory notes suggest that it is most appropriate for these third-party interests to be dealt with substantially at enforcement stage, and the appellant relies quite heavily upon that as an aid to interpretation of when Section 160A should be utilised. We respectfully say that that is inconsistent. There's a tension between that assertion and, in fact, the intention of Parliament. And in fact, it seems from the thrust of the Hansard that the drive which is represented by the introduction of Section 160A is in fact to ensure much earlier engagement of third-party rights at the point of the confiscation order.
Mr. Duffy, forgive me. The passage from the Secretary of State uses the word enable. The bill will enable the court to make findings.
Yes.
And the passage from the Parliamentary Undersecretary of State uses the expression will allow the court.
Yes.
There's nothing to suggest that this is mandatory.
No, I accept that. But the first certified question, my lord, is effectively inquiring as to under what circumstances when Section 160A can apply, should it be applied, and the appellants are suggesting, my lord, that in reality the weighting of these applications to the enforcement stage is in fact what should continue to occur, whereas on behalf of the respondent we respectfully submit that Section 160A should be used prominently and predominantly at the confiscation stage in order to give effect to parliamentary intent, which was to ensure greater efficiency and certainty within the process by having these matters resolved at the stage of the making of the confiscation order. So it is true that the wording of Section 160A reflects the fact that this is a power. It stipulates that in circumstances where the court feels it appropriate to do so. But we respectfully say that if this court is to give guidance as to when and in what circumstances Section 160A should be used, we respectfully say that the balance lies, if one is giving effect to parliamentary intention, the balance lies very strongly in favour of the use of Section 160A in the majority of cases, because not only does it give effect to parliamentary intent, but it also has the benefit of making the process more conclusive at an earlier stage, and also has the additional benefit of having respect for the third-party rights of individuals who may be affected by the confiscation order which the trial makes.
When do you say the rights under A1P1 are actually engaged by the orders made by the court? At what stage in the whole process?
Well, we respectfully say that once a court considers whether Section 160A applies, the court has to be satisfied that that a particular property is likely to be realised or otherwise used to satisfy the order, and that is a property which has an interest in it held by another party. So it seems inevitable that if a Crown Court judge concludes that Section 160A can apply, he or she must have concluded that there is a property with a third-party interest that is likely to be realised. So at that stage, we respectfully say that the Article 1, Protocol 1 rights are engaged, because the impact of the court making an order will have an impact, we say inevitably, upon the rights of the third party. And that is not the sole reason why we argue that Section 160A should be used predominantly in cases where it can apply, but certainly is one reason, in addition to increasing the efficiency of the legislation.
Well, on the question of efficiency, Mr. Madall makes the point that if Section 160A, if that route has to be followed on every occasion where it is apprehended that there may be some order that is required which has an impact on the rights of more than the defendant, that will mean that in very, very many cases in the Crown Court where a confiscation order is in contemplation, in order to fulfill the requirements of Section 160A, an elaborate examination of the interests of each party is required. And there must be, presumably, engagement of lawyers on behalf of the third party, which will inevitably lead to a protraction of the proceedings. I mean, what do you say about that?
Well, I say that is not necessarily so, my lord, because I accept, of course, there's no question that it is to the assistance of the prosecuting authorities if they avoid the need to deal with third-party rights. If, for example, compliance with the confiscation order is achieved without having to be concerned about the third-party rights of the other party, well, that undoubtedly will make life more simple for the prosecuting authorities. But
there's a slanted way of putting this without being concerned about it. I mean, what I think Mr. McDowell says is that, look, in the ordinary run of things, this will not present a particular problem. You will make the confiscation order, and you then will proceed to enforcement, and in the overwhelming majority of cases, that will be that. But here, if you're right, every time that the court is confronted with the circumstance that the property is shared with another, there must be an elaborate examination of the circumstances of the division to be made, that will inevitably mean that there will be a gumming up of the procedures before the Crown Court, and that these confiscation orders will be inhibited and prolonged. I mean, do you accept that there's any substance in that argument, or do you simply reject it?
No, well, not necessarily, because, for example, if one takes this case, in this case, the financial investigator made inquiries with the mortgage company to establish what their interest was in the property. The starting point for an assessment of the respective interest in the property is that which has been identified in Stack and Dowden. In the majority of cases, it seems to me that in the absence of evidence to the contrary, a 50-50 apportionment, I agree with my learned from Mr. McDowell, a 50-50% apportionment is probably likely, but one cannot legislate for every case.
Well, as a matter of, let's take this case, as a matter of practicality, if His Honour Judge Miller had turned his mind to the question of Section 160A, should he have solicited submissions from the partner of Miss Hilton?
Yeah, well, he was certainly required to notify the Mr. Hilton and to invite him to make representations. Now, if Mr. Hilton refused or failed to make representations, having been invited to do so, then the judge was entitled to draw such inferences from that as he saw fit.
But it seems to follow from that in every case where there is a shared property which is going to be subject to the confiscation order, the judge has to adjourn the proceedings and notify the third party, such as Mr. Hilton in the present case, and wait until it becomes clear that he's going to make representations or not.
Well, in fact, my lord, in practice, what happens is that the financial investigator, once the matter has, once there's been a conviction, the matter proceeds to sentencing. At that time, the financial investigator on behalf of the prosecution will already be making inquiries, if he hasn't already completed his inquiries, as to in trying to identify the assets of the defendant. So that work is already undertaken. And in fact, as in this case, part of that work, regardless of whether one activates Section 160A or not, that work will require him to ascertain whether there's a named party who also appears to have an interest in the property, whether there is an outstanding liability attaching to the property. All of that work is already undertaken.
Yes, I see. Thank you very much.
Well, All that would be required, my Lord, would be for an invitation to be made to the third party, and for the third party either to take up that invitation or not. And indeed, it seems that in the majority of cases it's likely to be capable of being resolved without much difficulty. And one of the cases which is cited at tab 13, Taylor and Butler, gives a very good example of how, and that was a relatively complex case, factually. It's a very good example of how those issues could be resolved by the Crown Court in an efficient manner, without too much inconvenience. But the fact of the matter remains that unless one completely ignores third-party rights, those rights have to be taken into account either at the confiscation stage or at the enforcement stage. And the saving that the Crown point to in terms of the efficiency of the process is the benefit which they derive from just simply not having to deal with third-party rights at all. And one of the practical difficulties, of course, is that if one doesn't advise a third party as to their right to make representations, if an order is then subsequently made, and then presuming that the defendant will then go back and say to the other party, listen, this is what has happened, an order has been made, I have to raise this sum of money, we have to do it by either mortgaging the house or selling the house. Unless the third party then goes and independently seeks legal advice, who is there to tell the third party about the rights that they might have at any stage, including the enforcement stage? So the very practical problems which arise in not engaging the process under Section 160A. And it is clear that despite the wording of paragraph 19 in the explanatory notes, where it suggests, however, in some cases, waiting only such interests only crystallise against specific property at this stage, that is the enforcement. So that simply is not correct. I think my Lord has already picked up on that. But paragraph 21 of the explanatory notes, my Lords and my Lady, at MS 477, just to come back to a point that the appellants were citing in support of their argument. At paragraph 21, the notes say, it is envisaged that the Crown Court would only make such determinations in relatively straightforward cases, that is, where the court considers it can, without too much difficulty, determine the defendant's interests in particular property. In deciding whether to make a determination in any particular case, it is expected the judges will exercise this power to determine the defendant's interest in property only in those cases where their experience, including in respect to matters as regards to property law, the nature of the property and the likely number and or complexity of any third-party interests allow them to do so. Now, the fact of the matter is that if these issues are left until in the enforcement stage, it is the Crown Court that has to deal with them at that stage. And so it seems nonsensical to suggest that on the one hand that the Crown Court should shy away from dealing with complex matters at the stage of making the confiscation order, when in fact, if they aren't dealt with at that stage and there is a dispute which survives the potential imprisonment of the defendant and the enforcement process, and there is a dispute later on, that it is in fact the Crown Court that ultimately will be dealing with them in any event. So the idea which is contained within paragraph 21, that the Crown Court should only deal with simple cases, is to ignore the fact that this isn't a split jurisdiction, and the Crown Court ultimately will have to deal with these cases at whatever stage they arise. So that we respectfully say cannot be right.
Can I ask you a question about Section 160?
Yes.
You have been focusing in your submissions on subsection 1, and you say that the rights are under A1P1 are engaged.
Yes.
When it appears that the property is likely to be used to satisfy the order.
Yes.
But could I ask you about subsection 3? This states that the circumstances in which a determination under section 160A is conclusive as to the defendant's interest in the property. And it's when that determination arises in connection with A, the realization of the property or the transfer of an interest in the property with a view to satisfying the confiscation order, or any action or proceeding taken for the purpose of any such realization or transfer. Doesn't that indicate that the point in time at which the third party's interest is engaged is the point in time when there's a threat of when there's a movement towards the realisation, or the realisation is occurring, not at the earlier stage of simply foreseeability that it may be realised.
Well, the prejudice to the third party might crystallise at the point of the realisation of the asset, but respectfully, the prejudice, the practical prejudice to the third party, we respectfully say, occurs at a much earlier stage, because it is their willingness to comply with the confiscation order against the background of all of these many disincentives, which effectively compromises their ability to properly assert their third-party rights. So,
why should they be any less incentivized or disincentivized if their interest has been conclusively determined at the early stage? They're still going to be quite likely to want. Suppose the court has decided that they own 3/4 of the property. They may still want to combine with their defendant partner in mortgaging it,
yes,
to enable that partner to pay the confiscation order and not to go to prison.
yeah, and well, that's entirely right. But at least the advantage that they would have in those circumstances is that their interest in the property has been properly assessed, and that they are not making a compromise as to their interest in the property for the practical reasons of avoiding a custodial sentence for their partner. And indeed, situations may well occur where, for example, the parties are separated or separating as a consequence, and where there maybe isn't a common interest between the parties as to their futures, and the third party may be less willing to engage in cooperating with the process. But it seems to us that the third party rights, regardless of whether they want to comply or not, provided if a determination is made under Section 160A, at least they have the opportunity to have their rights considered and resolved at that stage. And then the advantage, of course, for the proceeds of crime legislation itself is that that has the advantage of having a determination at an early stage, which is effectively binding, and it means that there won't be any further interference in the process if it comes to the enforcement stage under Section 198 or 199. It means that the court is not going to be embroiled in the kind of legal argument and court hearings that might slow down and add to the cost of realising the property. So there are many advantages to having the matter resolved, third-party interest resolved under Section 160A, just as was imagined in the parliamentary debate.
Can you just help me a little bit about how this works in practice? As I understand it, the confiscation order is made, usually at the sentencing hearing?
What happens is that once the sentencing takes place, the confiscation hearing is postponed.
Right.
Certain information is gathered by the financial investigator. An affidavit is often required from the defendant to establish under oath what their assets are.
Sort of affidavit of means.
Yes,
yeah.
And the judge will then often determine the confiscation order on the basis of all of that information available to him.
At a single hearing.
Yes.
And the rule, can I assume that the Crown Court rules don't make provision in advance of that hearing for notification of any third parties in the way that they do in the advance of hearings for appointment of a receiver?
Yes, no, they don't. That's correct.
So that a judge, in deciding whether to go down the 160A route, unless he somehow reads the papers on a sort of docket basis before the hearing, won't know at any stage before the effective hearing whether it's going to be a good, bad or indifferent case to go down that road.
I think it probably will depend upon the case, because the information, the judge obviously having heard the criminal case will have some information about the circumstances of the defendant.
He's not going to know much about third-party interests in shared property.
But of course the amendment introduced by the 2015 Act also introduced additional additional powers to the Crown Court to require further information, either from the prosecution under Section 166 6A, 6B, by way of a statement of further information, which contains information about potential third-party rights, and also under Section 160A, provision of information as to defendant's interest in property. So there are additional weapons in the court's armoury to allow it to inform itself in advance of a confiscation hearing.
But I mean, in practice, are they used, or is a judge who's hearing a conversation for the first time, not the sentencing hearing, because the affidavit of means and so on won't have been sworn?
No, that's true.
Having to face the not terribly attractive alternative of either adjourning it off to a further hearing for the purpose of determining third-party interests, or taking the chance whether the matter will need to be dealt with at all at the enforcement stage.
Well, the judge could adjourn the matter if he felt that was required to allow a third party to make.
Well, I can see he could, but he obviously wouldn't want to have a delay at that stage, merely in the hope of possibly avoiding the possibility or small risk of a delay at a later stage. Or he might not want to. Well,
it's possible, but in terms of Section 160A, in terms of the job that the Crown Court judge has to do at the point of making the confiscation order, yes, no question it involves more work for the judge, and it does require him to, in some cases, I would have thought, to make an evidential assessment as to the material that's placed before him. In a lot of cases, that is likely to be relatively straightforward, where there is where the starting point of a 50-50 share in the property is not displaced, and if the third party is given an opportunity to make representations and doesn't dispute that, it actually then becomes a not particularly difficult process for the Crown Court judge then to engage in, and then he has all the benefits of having made that determination under Section 160A. There may well be cases, and Butler and Taylor is probably a useful example, where the factual circumstances are a little bit more complicated, and where a judge has to engage in an evidential hearing and make a decision as to whether or not the presumption of 50-50 has been displaced, and it wasn't in that case. But at least it has a series of advantages, and it isn't always administratively very additionally burdensome to the judge, because these tools are here to allow him to acquire the relevant information from the prosecution, from the defendant, from the financial investigator who supplies information to the prosecution, and if requested from the relevant third party, and that can all be done in a single hearing, one would have thought, and resolved in many cases. I would expect relatively quickly, albeit though I accept that there will be more complicated cases. But those complicated cases, if there are very complex issues that need, even if it's something which requires the appointment of a High Court judge with the relevant experience to sit as a Crown Court judge to hear those issues, if those complexities exist at the point of enforcement, they also exist at the point of confiscation. Ignoring those issues and shying away from at the point of the making of the confiscation order does not in any way assist the process if they are ultimately going to have to be dealt with at the enforcement stage in any case. And indeed it was the additional delay and expense created by these issues being raised at the enforcement stage by third parties, which was very much at the heart of the parliamentary debate, where they were seeking to try and overcome that fairly common problem that was prevalent within the system. Various debates which are contained within the skeleton argument, which refer to that. But the use of the explanatory notes as an aid to the interpretation of the legislation and as a guide as to when it should be used, we say should be approached very, very carefully. We cite from Benyon on statutory interpretation, which is set out at tab 30 of the bundle, which is page 635, and Just to quote very briefly from that, my lords and my lady, at page 636, Benyon quotes from Lord Justice Brooke's judgment in Flora and Wacom Heathrow Limited, and paragraph 15 refers to the Westminster City Council case. And then paragraph 16, and this is quoting from the Flora case, the authors quote, "The text of an act does not have to be ambiguous before a court may be permitted to take into account an explanatory note in order to understand the contextual scene in which the act is set. Insofar as this material casts light on the objective setting or contextual scene of the statute and the mischief to which it is aimed, it is always an admissible aid to construction." Lord Stein, however, ended his exposition on the value of explanatory notes as an aid to construction by saying at paragraph 6, "What is impermissible is to treat the wishes and desires of the government about the scope of the statutory language as reflecting the will of Parliament. The aims of the government in respect of the meaning of the clauses as revealed in explanatory notes cannot be attributed to Parliament. The object is to see what the intention expressed. The object is to see what is the intention expressed by the words enacted." And at the bottom of that page, the penultimate paragraph, where the authors resume a commentary, reads, "Although it is well established that explanatory notes may be used to shed light on the contextual scene of a statute or the mischief at which it is aimed, the courts have been at pains to point out that the notes must not be allowed to supplant the language of the legislation itself." And indeed, at the ultimate paragraph makes the observation that when considering the value of explanatory notes as an aid to construction, it is also important to bear in mind there's always a risk that the notes will be wrong or misleading. And the case, in fact, to which the authors were referring was the case at tab 1 of the bundle of authorities, which is the Chief Constable of Greater Manchester, Wright, in which as a commentary towards the end of the judgment, this is at page MS 155, at paragraphs 24 and 25, Judge Hodge, QC, who was hearing the case, referred to paragraph 437 of the notes and ultimately concluded, in fact, that the notes were incorrect. He says, in the third line of paragraph 24, he says, "It seems to me that the note cannot be construed as extending beyond civil recovery proceedings." And paragraph 25, he states, "It seems to me the explanatory note is potentially misleading." So there is a need for caution, it seems, when considering the benefit of explanatory notes in interpretation. We respectfully say that such caution would be well founded in this case.
Well, you place quite considerable reliance on Hansard, and the circumstances in which a court may have recourse to Hansard are significantly more circumscribed than those in which we may refer to the explanatory notes. Isn't that right?
I accept them, Lord, but if one goes back to the explanatory notes and applies applies an analysis of them when compared to the benefits that they are suggesting for dealing with these cases at the enforcement stage, we respectfully say that even on that form of analysis, in addition to looking at the wording of the legislation, when one analyses what the explanatory notes contend, that it is better to deal with these third-party interests at enforcement, we respectfully say that clearly is not correct on any analysis. The suggestion that they would be better dealt with at enforcement stage because the Crown Court should only deal with simple factual disputes is made a nonsense of, because it's the Crown Court ultimately that has to deal with them at enforcement. Dealing with them at enforcement stage prolongs the process. Dealing with them at enforcement runs the risk that third parties will surrender their rights for reasons of expediency to avoid a custodial sentence being served by their partner.
But that's not logically correct, is it? If by the time it gets to enforcement, the number of cases in which third-party interests are relevant is significantly reduced.
Well, that may be because the third parties surrender their rights in order to avoid the potential consequences which might be visited upon the defendant if they fail to comply with the confiscation order. And I think in our skeleton argument we refer to some of the various problems that have been identified as occurring if one fails to comply with these orders. Millington and Sutherland, this is at it's MS 70 of the first bundle, and it's paragraph 53 of our respondent's skeleton argument. And Millington, we refer to to Millington and Sutherland, and we cite a number of problems which have been identified by the authors to those who fail to comply with an order. The text of Millington to which we refer is set out at tab 32 on the bundle of authorities, and that's at page 649, Lords, my lady, and and at page 649, this is paragraph 11.09 of Millington and Sutherland under the heading of voluntary satisfaction by the defendant. And the authors suggest in most circumstances the prosecutor should give the defendant an opportunity to satisfy the confiscation order voluntarily before taking enforcement action in the courts. It is very much to the defendant's advantage to cooperate with the court and prosecutor in the voluntary satisfaction of the confiscation order for the following reasons. And then there are a whole series of reasons cited, including he will be liable to pay interest. 2, it will reduce the risk of a prosecutor applying for the appointment of an enforcement receiver to realise the defendant's assets in satisfaction of the order. 3, if the order is satisfied prior to time to pay expiring, the defendant will avoid any risk of having to serve the default term of imprisonment for non-payment. Refers then to a restraint order, which doesn't apply in this case. And finally, voluntary satisfaction of an order may avoid assets being sold by plaintiffs or by bailiffs at a public auction where they may not realise the values attributed to them in the Crown Court proceedings. And indeed, there's another potential difficulty, of course, which was identified by Lord Briggs, and that is the potential power that a court can provide to an enforcement receiver under section 1992A to take possession of the property, and that is a power which can be provided to the enforcement receiver without the need to allow third parties to make representations.
Well, except that the Crown Court rules expressly provide for third parties to be notified at the outset of the receivership process.
Well, it certainly the legislation doesn't provide for representations.
Not the primary legislation, no.
Yes, but it highlights the significant and difficulties and the multitude of problems that are potentially faced by allowing the matter to proceed to the enforcement stage. The disincentives that are there to the defendant. I mean, by way of an example, one could offer a defendant the right to appeal against a particular ruling, but if one says that the court fee for applying to lodge an application to appeal the ruling is £30,000, whilst ostensibly one has a right to appeal and make representations, the disincentives to doing so generally effectively remove that opportunity. And we say in the circumstances where these issues are left to enforcement, by that stage, a lot of potentially genuine and proper cases of third-party interests being impeded fall by the wayside and are never, in fact, determined. And in those circumstances, the justice delayed is justice denied to those third parties. So it is for those reasons, not just, my lord, our observations about the contents of the parliamentary debate. It is for those other very practical reasons that we respectfully say that the proper interpretation is not what the appellant suggests, but rather what the respondents have put forward, that the use of Section 160A should be prominent in order to avoid these problems and to protect third-party rights. And I think that probably...
It's all helpful, but it's by the way, isn't it, really? The actual construction of Section 160A is not complicated, and one doesn't need any real assistance, whether from explanatory notes or Hansard, to see what it says. It gives a discretion. Is there anything more you want to say about whether this was a discretion that was exercised by the judge in this case?
Well, the judge, in this case, I accept, it was not, his attention was not drawn to the provisions of Section 160A. It seems to us clear, and we submit that he did in fact make a determination. When one looks at the...
He did or didn't?
He did make a determination, my lord.
His order amounted to a determination.
It did.
Perhaps a better way of putting
Yes,
it.
whether he...
But my lord's point is a very pertinent one, and that is, did he exercise a discretion? I mean, if Section 160A is determined, is dependent on the exercise of a discretion, if the judge was quite unaware of it, as he plainly seems to have been, how can it be said that he exercised his discretion?
Well, if one looks at the wording of Section 160A and applies it to the process that was undertaken by the Crown Court judge in this case, where it appears to a court making confiscation order that there's property held by the defendant that is likely to be realised or otherwise used to satisfy the order, well, that would have certainly been apparent to the Crown Court judge. And a person other than the defendant holds or may hold an interest in the property, that also was certainly known to the judge. The court may, if it thinks appropriate to do so, determine the extent of the defendant's interest in the property. So we say...
Well, he plainly didn't do that. I mean, he didn't address the question of whether it was appropriate for him to do so, because he wasn't aware of the provision.
Yes, I agree. He certainly didn't consider the question of whether it was appropriate to make an order under Section 160A, which ultimately would have been binding.
Well, how can he be fixed with the determination under Section 160A if he didn't exercise a discretion and was utterly unaware of the provision?
Well, I agree that it would be difficult to fix him with a criticism for not exercising a discretion that he didn't.
No, I'm not suggesting that one embarks upon a possible criticism of the judge, but your argument, as it seems to me, drawing, and in fairness to you, on the judgment of the Court of Appeal, is that although he was unaware of it, although he didn't exercise a discretion, and although the provision requires the judge to address the question whether it's appropriate for him to do so, nevertheless, he is fixed with a determination under a provision of which he was completely unaware. It seems rather difficult to say that in effect, he is to be regarded as having made a decision under Section 160A when intrinsic to that, inherent in the provision, is the exercise by him of a discretion as to whether it's appropriate to do so. How can he be fixed with that if he simply didn't address the question of whether it was appropriate for him to do so at all?
Well, I accept that he didn't. He wasn't exercising a discretion, given that he was unaware of the section. But the practical effect of the order, my lord, was to effectively stipulate the interest held by the defendant in the property. So that was the practical effect of the order.
But won't a judge have to do that in almost every case where the shared interest is a significant part of the defendant's assets? Because you can't value, which the judge must do, that interest in shared property without working out what percentage of the whole it represents.
Yes, but that wouldn't have to be done in every case, my lord.
No, but in every case where it's a significant part of the defendant's assets and the benefit is, as it were, off the scale. In other words, you're really looking to see what the defendant has got with which to make restitution.
Yeah, so in every case where where it's likely to be realised, then yes, we say that that it is appropriate, and in fact a judge should embark upon a determination under Section 160.
He's required to. He's in fact required to.
Well, unless, the Section 161 states the court may, if it thinks appropriate to do so.
Yeah.
So the court does have a discretion. There's not really very much guidance as to, certainly in the language of the legislation, as to when it may or may not be appropriate to do so. But one can imagine a number of circumstances. For example, the one that we cite is a situation whereby the equity in the property so massively outstrips the benefit to be recovered for the confiscation order that it seemed to be to the Crown Court judge unnecessary to embark upon a dissection as to the relative interest. So that would be one circumstance, but I imagine that the factual circumstances of many other cases coming before the courts are likely to provide other examples as to when a court may not consider it appropriate to do so, my lords.
Mr. Duffy, if the judge sitting in 2014 had done precisely what he later did, and if we'd been analysing it, we would have said, wouldn't he, well, he's simply working out the available amount under Section 159. Fine. But you say, because of the advent of the 2015 Act, and notwithstanding that the available amount legislation is entirely the same, what he did when he did it, after the 2015 Act came in, means that he did it under Section 160A, even though he didn't know about it, rather than doing it under the conventional available amount
yes.
inquiry.
Well, of course, the certified question isn't targeted as to exactly what the judge did in this particular case.
But you'll be conscious that we're not bound by the terms of the certified question.
No, I understand that, my lord. But yes, had it been prior to the introduction of Section 160A, it would have been the judge's actions in all likelihood would have been interpreted as simply an assessment as to the share, as opposed to a determination of it. My learned friend, Mr. McDowell, made a reference to the use of the word to decide and to determine. And again, there's not a great deal of assistance within the legislation as to why that particular language is used. But certainly prior to the amendments introduced by the 2015 Act, it probably would have been regarded, well, it could only have been regarded as an assessment because there was no provision to consider or to deem such an assessment as binding. But that's not to lose sight, I have to say, of the other overarching point that we make about the need to properly consider third-party rights in compliance with the Convention, which we say, despite it never having been taken as a point before, we respectfully say that it nevertheless is an issue which applies now, and which in fact probably could have been held to apply prior to the introduction of Section 160A, and that is an overarching argument which informs our interpretation of Section 160A and informs our response to the certified question, Lord. Unless there's any additional.
Thank you very much indeed, Mr. Duffy. Mr. Curran?
I have no further submission.
Yeah.
Thank you, my lords.
Mr. McDowell?
No, nothing in reply, my lord.
Okay. Right, well, thank you all very much. It's customary to say for this very interesting exposition of an intriguing problem that might perhaps be carrying insincerity a little too far. But no, it's very complicated, and it's obviously extremely important, and we're very grateful to counsel who appeared before us and made their oral submissions, and of course to those who laboured in the field before the presentation of the oral arguments. We will, as Lady Hale puts it, we'll go away and struggle to find the right answer. But in the meantime, we're very grateful, and the court is now adjourned.